Item number 1 to 6. Number 7 to 17. 18 to 25.
May I please, Your Lordship? I beg to mention item number 14. The
One
matter-
four.
14.
Yes.
The matter may kindly adjourn for the day, Your Lordship. Only for the day.
Counsel for the appellant prays for time. List after 3 weeks.
Much of it.
May I please, Your Lordship?
Yes.
Also, with the consent of the other side, I beg to mention item number 16, Your Lordship.
1-6.
Lordship may grant us 1 week's time to file affidavit.
And counsel for the appellant petitioner prays for and is granted 2 weeks time to file an affidavit. List up 2 weeks.
Obliged.
May I please, Your Lordship? For listing of a matter appeal, Your Lordship.
Relax.
For listing of matter appeal, Your
What
Lordship.
is the matter about?
Is a matrimonial appeal, Your Lordship,
All right. When do you want it to be listed?
on 19, Your Lordship.
19.
Obliged, Your Lordship.
19, the office would list it otherwise also. Why do you need permission?
Your Lordship. It's not.
We have instructed the office not to delist any single matter. Any matter which is filed, it is to be listed as per
No, Your Lordship, not a new matter, Your Lordship. That's an I.
the old matter. IA.
Yes, sir.
All right. Okay.
Obliged.
Yes.
May I please, Lordship? My lord, this matter was regarding election of cooperative societies, madam. The other day it was listed, I was busy in another court. Lordship directed to be listed after 2 weeks.
Mm.
So 2 weeks has already passed. You may kindly list it tomorrow, madam. Maximum urgency.
What is the date given? Find out.
Tomorrow.
What is the date given by the office?
The official, your lordship passed the order list after 2 weeks. And that time it was last question 27/3. So in
All
that
right, listed.
tomorrow.
Yes. Okay.
May I please, Your Lordship? Lordship, I beg to mention for listing a matter.
What is the
Tomorrow,
matter
yeah.
about? What is the matter about?
Lordship, this matter is related to the eviction matter in Silk House.
Eviction.
Yes,
So is it a writ petition or an appeal?
petitioner, Lordship petitioner has approached this honorable court. And in single bench, landed single bench.
So it is a writ appeal. It is a writ appeal.
Yes,
When was your writ petition decided?
it was decided on 3/3.
3rd March. All right. List it on 19th is okay? 19th,
Matter is urgent. Landed single bench has stayed till today only.
list on 12th then. Very well. 12th.
Lordship, kindly, it may be tomorrow or
All
day
right.
after
Tomorrow.
May it please, Your Lordship. Lordship, these are certain single bench matters where your Lordship has called for these single bench matters. It involves questions of constitutional validity of certain OM, of an OM, where the impugn clause has been challenged.
Mhm.
The writ appeal is before my lord.
Mhm.
And the last occasion, your Lordship was pleased to call the single bench matter where the new OM, again, my lord, which has emanated from the same judgment, my lord,
Mhm.
that has been called for. So, my lord, these are similar matters. If I may pray, my lord, these
When are
matters
the matters coming up?
My lord, on 25th, it has been fixed for hearing, my lord.
Mhm.
My
So
lord,
you make a mention 2 days earlier.
my lord,
Make a mention on 23rd. We'll direct the office to list them on 24th. You can make a mention on 21st. Okay.
my lord, if I may pray, my lord, if I today I make a mention, my lord,
Mm.
they will be able to take the, my lord, they will be able to tag it up along with on 25th. my lord.
Go and find out what is the issue. Get the files. We'll have a look at the files. Sir.
Highly obliged, my lord.
Yes.
May I please, Your Lordship? Beg to mention item number 10. My senior is out of station. Lordship, kindly adjourn the matter. We have taken consent from the petitioner side.
A fresh matter you don't want to argue. All right. And counsel for the petitioner submits that the arguing counsel is not available today. And thus the matter may be adjourned. List up 2 weeks or 3 weeks. When do you want?
Your Lordship, she's going to respond and I'm going to petition.
Respondent. You are for the petitioner.
Yes, Your Lord.
So do you have any objection?
No, Your Lord.
For the respondent, praise for it. Petitioner's counsel does not have any objection. List after 2 weeks.
Obliged.
Item number 1 for orders.
Lordship. Matrimonial appeal, Lordship,
Yes.
wherein we have filed a petition under section 25 of the
Mm.
Hindu Marriage Act. They have filed written affidavit in opposition. wherein we have filed again rejoinder affidavit.
Rejoined affidavit you filed, all right.
Lordship, we were granted that appellant was granted 8,000 rupees per month. Maintenance pension life. So as you be taking it that his income as 50,000, 67,000.
Is he employed?
He is employed.
All right,
He is a medical representative
okay,
and he has no other liabilities. Mother is a pensioner, railway pensioner. And he has residential houses wherein commercial houses is also there. So he is earning some profits.
is there anyone representing the respondent?
He was all along representing him. Her.
Now, on the last date also, Mr. Jha was there.
Yes, Lordship.
Let's pass it over. Let's wait for Mr. Jha.
Lordship.
All right.
Matter number 2,
Yes, service.
May I please, your lordship?
Hmm.
Lordship, service is not complete here.
But you were
Not divorce, lordship. This is a father and daughter matter.
father and daughter's urgent,
Lordship.
we understand. But on the last date, you mentioned that you will be providing
Lordship,
the posting place
yes,
details.
lordship, he's posted in New Delhi, but my client doesn't know the address of her father. He's in CRPA. She's unable to find anything.
All right, the respondent is land counsel for the appellant states that the respondent, being the father of the appellant, is posted at some place in New Delhi, in CRPF New Delhi, some position in CRPF New Delhi, but the appellant does not have any proper information about his place of posting. In view of the peculiar facts of the case, the notice of the respondent may be forwarded. Notice for service upon the respondent may be forwarded to the who would be the authority in Delhi, the highest authority of CRPF? Ms. Nair?
It will be the Director General.
Director General of CRPF, New Delhi, to ensure that service is effected upon the respondent. Are there any, say, kind of serial number or the details of enrollment of the respondent? There is a particular number
Yes,
provided.
lordship,
You
we
don't even have
no,
that.
lordship, because lordship, he's living with his second wife and children, so I am not even allowed to go near.
But you could have, in the family court, didn't you have access to that
No,
detail?
lordship, no, lord.
It was an ex parte order.
He was present. It was not an expert order. He was present in the family.
All right. To the Director General of CRPF, New Delhi, through registered ID post as well as through email. The notices shall be forwarded to the Director General shall be forwarded with a request to ensure the service thereof upon the respondent. Full stop. The notices upon service shall be returned with the complete service details, including salary, etc., of such respondent. List on 23rd May. You're right, take few lines. The appellant herein is the daughter of the respondent. She seeks a direction for award of maintenance from her father through this appeal. Despite repeated efforts, service has not been effected on the respondent who is serving in the CRPF. In this way of the matter, then we'll mention like that.
Much of it.
All right.
item number 3,
Yes. Seven lakhs has been deposited,
My lord, not deposited yet, my lord.
then
My lord, I have a request on behalf of my client, my lord,
hmm,
that since the matter is pronounced on my absence when after the filing WS and after attending 3 days of counseling,
Hmm.
when I was unable to attend the trial court.
Hmm.
And the amount which was been ordered by this honorable court and which is a part of a joint account, which
Hmm.
was not been, my client could not contest that this amount is actually withdrawn by my client, or actually because the joint account is both of us has the joint access of that account, where the respondent is also able to withdraw the amount, and that amount is disputed. And so far till today, my lord, only 90,000 is to be paid to the respondent, and with that request, I'm appearing today, my lord.
Sir, you are in appeal. You did not appear in the family court. The proceedings were ex parte. You had an occasion to advise your client to file Order 9 Rule 13. You did not do so.
My lord, we appeared, we filed WS, and
Then did you contest the case? Did you cross-examine the respondent? Her case is uncontested. Her evidence is uncontested. What is the court required to do?
my lord, because my reason of my absence is genuine, my lord.
Oh, understood, sir. Then you had to file a 913 for setting aside the ex parte decree.
It was not done, my lord.
But unfortunately, in this court, none of the advocates advises the clients accordingly. In every case, we find an appeal. Appeal can be brought, no doubt. But then why are we supposed to question her evidence or evidence of the other side, which has not been tested by cross-examination? Let us know. We'll dismiss your appeal and then we'll direct the family court to execute the decree. All right. Now you are in non-compliance of this court's direction. Why should we hear you on merits?
My lord, may I pray for another short date, my lord, because the client is on the also here. May he will do accordingly whatever he advised to do, my lord, because I have
We have already
repeatedly
given you
advised
the
him to
opportunity,
comply-
sir.
Comply the court's order, my lord.
How many opportunities have been given?
One opportunity, my lord.
20th January order was.
20th January order, then 20th March order. So now this is the 4th month running. All right, on the request of Mr. Sharma, last opportunity of 3 weeks is given to the appellant for making deposit of rupees, for depositing a sum of rupees 7 lakhs in terms of the order dated 20th January 2023. If the appellant fails to deposit the amount as directed, this court shall consider dismissing the appeal on account of non-compliance of this court's direction.
Mr. President.
On 8th May.
Mr. President.
Item number 4.
Yes. Ms. Talukdar, some progress has been made.
Lordship, I have the latest inspection, Lordship.
What? Have you moved out of the Stone Age?
Lordship, out of
No.
469, Lordship, 444 we have already issued, Lordship. 10.
Yes,
will be
Mr. Nair,
Lordship.
the directions are started bearing fruit.
Showing action.
Yes,
But the only problem is when the officers had come down for the Platinum Jubilee celebration, madam, I had a discussion with many of them,
yes.
but they are yet to, as on that day, receive this message. Because this seems to be sent by speed post special messenger. They could have just mailed it out, my
Lordship,
lord.
there is some.
Mr. Nair,
Lordship.
I don't want to make a comment.
No, I
Straight up, just hold on. Just give me, Ms. Rupam, give me some other file. With due respect, we may have talked so much about digitization and everything. Oh, Joe, fees deposited. I'm at a loss to understand in what age are we living. Have you seen what kind of court fees are being paid here? What is the amount?
For writ petition, my lord, I think it's 60 rupees. One.
58 rupees 80 paisa.
Something.
There, I have seen deposits of 3 rupees 30 paisa. Where are we living?
That's true. That's true.
Is it the same country?
Not true.
Probably in my parents' state, we left these things behind 20 years back.
My lord, since I have joined, I think it's 50 only. Since I,
Ah,
97, 98 months.
80 paisa. How does a man pay that?
Lordship. These have to be revised, madam. I tell you.
Anyhow, so as per you, the officers have not received.
But the information they
Why
gave me, ma'am,
speed post?
Lordship, we are sent by. speed
Now,
post
this
and-
is all to be transferred online, sir.
Lordship, we are taking steps, Lordship, to upgrade the software. to
You
change
keep
the
your officer present day after
software
tomorrow.
system.
keep your officer present day after tomorrow.
Lordship, we are taking steps, Lordship. May kindly peruse our letter inspection, Lordship.
The very fact that your letter says by speed post, that is sufficient reason to call your officer at the court.
Lordship, because every Lordship, the pay slip cannot be sent through email, Lordship, because of security reason, Lordship. Because Lordship,
Is that so?
that's why
is
we
it
are
so?
upgrading the system so that the
Mr. Talukdar, you need not even generate the pay slip.
Lordship,
Everything is done electronically nowadays.
Lordship, now we are taking steps, Lordship,
What
taking
steps? What steps?
to upgrade into the software system. Lordship, may kindly peruse we are installing GEM system, Lordship.
Hmm.
Lordship, which is a secured, Lordship, a secure
So-
system of,
Does it take 10 days to wake up the system?
no, Lordship, entire
It
system has
takes
to be.
a fraction of a second. A command is given and the amount is transferred.
Lordship, we are, it was not before, Lordship, we are taking just steps now, we need to upgrade all this into, despite into the software system, Lordship. Lordship, we kindly peruse of the latest instruction, Lordship.
So how much time do you want? We want this process to be digitized forthwith. No paper communications in this regard. The moment this is as per entitlement, this has to be on a schedule.
Lordship,
Maybe on
That's-
31st March, you may delay it by a few days,
Lordship.
but we are not living in Bihar. There I'll let you know, the salaries of judicial officers are delayed by months together.
Lordship.
But Assam is not equal to Bihar.
That's,
So
uh,
we are giving you time of 7 days.
Lordship.
The entire system has to go paperless. Or else your entire officers will be paraded, fleet of officers,
Lordship.
including the chief secretary, will be here in the court.
Lordship, that is the 14 days after 14 days, Lordship. Matter may be listed after
My lord.
14 days, Lordship.
One thing they'll ensure, because in the last proceeding also they had ensured
Hmm.
that there would not be a requirement of a judicial officer approaching their office, either the judicial officer or his representative.
Nobody is required to.
That, my lord,
Nobody is required.
they'll have to ensure that.
Lordship, we have stated our officer was approaching the registry for getting the emails. In some cases, we have not received the email, Lordship. That has
Alright.
been
That
stated.
if
in
there
the
is something, my lord, let them just send a mail.
Yes,
We'll take-
yes,
take
yes.
necessary
You send a query to the registry, the
Not that
registry will
much.
respond.
about it.
There is no need for your officer to come to registry.
No.
Everything can be done via email.
That's true, Lordship.
There are secured systems of communication. Don't tell us that you can't say send pay slips through communication. They'll be encashed on the way.
That can be the.
They will be looted on the way through internet.
It's not a bearer check, my lord.
All right, we are sending this letter to the Registrar General. Let us see
Hmm.
how he responds. All right, in compliance of the order dated, in furtherance of the order dated 3rd April 2023, the matter was taken up in the office of the Principal Accountant General A&E Assam. First up, a letter dated 6/4/2023 has been placed on record by Mr. Talukdar, which indicates that pay slips of 444 out of 469 judicial officers serving in Assam have been dispatched via speed post / special messengers. This fact in itself indicates that the office of the PAG is still working on obsolete systems. These communications have to be made electronically by email, etc. Thus, the letter also indicates that the transition to paperless system could not be made because emails of some of the officers are not available. Full stop. If that is so, the Registrar General Guwahati High Court shall ensure that emails of each officer each and every officer serving in the judiciary of state of Assam are provided. Assam, all 4 states, or we are
Only Assam.
Assam are provided to the office of the PAG within the next 3 days.
Lordship.
Latest progress report shall be submitted for the court's perusal on next date of listing, denotify on 26th April.
My lordship, on that day, they will place before my lord the roadmap for electronically.
On that day, the roadmap for transition to electronic system of working shall be placed for court's perusal.
Much appreciated.
Item number 5,
And Mr. Nair, you need to, at least some of you who have the means and the knack to do so, start filing, making e-filings.
I'll do
You
that.
just alter
I'll
your
do
own things.
I'll do that. Madam.
Someone has to make the beginning.
I'll do that.
All right.
My next filing.
It can
will
be
be
Mr.
refined.
Nath, Mr. Das. Yeah, you are all people adapted to technology.
I'll do that.
Yes,
May I please, Your Lordship?
yes.
Well, which condemnation matter, new matter, notice may be issued now. In
This
a
MAT,
matrimonial appeal, man.
well, how much is the delay?
Delete money.
The proceedings before the
295 days.
proceedings before the family court were ex parte.
Yes, my lord.
Why don't you advise your client to file
Only
order
thing-
913
My lord, thing is that, my lord, there is a stay order from this honorable court, my lord.
for
Stay order of the proceeding, my lord.
which proceedings?
My lord, this family courts matter, my lord. Because wife was praying for, my lord, transfer of this matter from, my lord, Kachar district to Hailakandi district, my lord.
Hmm.
Accordingly, my lord, it was stayed, my lord. But this stay order was not put on the record, my lord. And therefore, my lord, this order was passed ex parte, my lord.
So whose fault that the stay order was not brought to the notice of the family court?
My lord, this is, my lord, perhaps, my lord, as per my instruction, my lord, this order was, my lord, placed before the, my lord, bench assistant, my lord. But perhaps, my lord, he could not, my lord,
Rupam,
brought to the notice. of
need
the-
to present this file to me because these stay orders, they are required to be communicated immediately. Compliance should go or not. You know, compliance already, even if it is sent physically, it should be transmitted through email immediately. But anyhow, whether it was sent or not, bring it to my notice. All right. Issue notice, issue notice heard. Issue notice of the application under Section 5 Limitation Act. The respondent rule is made returnable in 6 weeks. Steps for service be taken in 7 days.
Table of law.
List of 6 weeks.
item number 6,
May I please know?
Yes,
There was delay of 36 days of filing of the appeal, my lord,
yes.
against the degree of
Uh,
judicial separation.
issue notice of the IA number so and so. Filed under Section 5 of the Limitation Act to the respondent. Rule is made returnable in 6 weeks. This respondent is a judicial officer.
Yes, my lord, he was.
Steps for service be taken in 7 days.
item number 7,
May I please, Your Lordship? There is a delay of 173 days in filing the appeal, Lordship.
Writ appeal, what is writ appeal about? Against what order? What is the order
Uh,
of which you are aggrieved?
Yes, order of the.
Is it page number
Like-
84 of the appeal?
You are appealing already?
I'm
What do you, for the private respondent or state?
What is state respondent?
All right. They're all state respondents only.
All of
No,
them.
there is a corporation also.
I'm appealing for the corporation.
All right. Number 1 would be required to put in a, you will be presenting one also.
No, the government will,
All right.
no, commission secretary.
What do you say? Should we condone the delay in year and merits?
Personal difficulty of counsel, Your Lordship.
All right. Issue notice of the application under Section 5 of the Limitation Act. Ms. So and so appears on behalf of so and so. Then counsel representing the respondents. This application has been filed seeking condonation of delay of 173 days. 173 days occasion in filing of the connected appeal. Counsel for the respondents do not object to the prayer for condonation which is made on account of personal difficulty of the counsel, which occurred on account of personal difficulty of the counsel. Thus, the application is allowed. The registry shall number the connected writ appeal and list the same for admission accordingly. Extra copies of the writ petition, writ appeal shall be served on the council representing the respondents today itself.
Obliged, deeply obliged.
Item number 26 of supplementary list for orders.
Yes,
Lordship, my last occasion, the Lordship wanted to know about the order of the Honorable Supreme Court,
yes.
page 135, Lordship.
Yes, read please. What is the order? The order was that if the representations are filed, they shall be
Yes.
responded.
Yes, Lord.
Whether your criminal cases have been registered thereafter,
No, Lordship, that was registered in 2006 for one cause of action.
then
Then they have not done anything. Thereafter.
you could have filed a complaint, madam. Go to the court, file a complaint under section 200.
Lordship, my petition is regarding the inaction of the office, government officials, Lordship.
What inaction?
And private respondent in collusion with the some of the of government officials.
Yes.
Manipulated the records inside the office of the respondent number
So
3.
do you want us to take these evidences in writ petition, please? You
Lordship,
file a complaint, you file a suit, whatever you want to do.
suit is for different purpose, Lordship, for against the private respondent, Lordship. I cannot do anything against the officials.
Let us
government
see your,
officials, Lord.
let us see your pleadings against the officials. Which official is responsible? Is there any official by a
I
person,
have
by a
a-
name?
I have.
Is any official implicated
Yes,
by name?
The police of that I am
Let us see.
yes,
Who is implicated by name?
by name one person. 8 Lordship, respondent 8.
Yes, Inspector of Police,
Yes, Lord.
Narayan Patangya.
Yes.
All right, what is your allegation against him? Let us see.
He has, despite filing of subordinate FIR before him, Lordship.
So
did
he doesn't register the FIR, then you file a complaint in the court. What prevents you
not,
from doing so?
before the SP, I have filed Lordship.
Madam, there is a procedure called section 200 CRPC.
Yes, Lordship.
So if the police is not registering, go to the court, seek a direction for 156(3).
Because Lordship, my contention before this honorable court, Lordship, that the private in collusion with all the government officials, they have manipulated the records of the inside the office official.
What is the date of manipulation of the record? When did they manipulate? Which year?
2006 itself, Lord.
2006, all right.
Yes.
Thereafter, you filed an FIR, which was registered pursuant to the direction of the Supreme Court.
No, pardon, that was registered before that. One cause of action.
So what prevents you from filing yet another FIR, madam?
I have submitted before the government officials for protection of my life and liberty and property of the petitioner.
Life and liberty. How many times has the petitioner been assaulted? What threat has been caused to her life? Let us know.
No, not assaulted, but they have.
Then what is
threatened
what kind of threat has she felt to her life?
life and because they prevented the petitioner's attorney to enter into the land of the petitioner. Lordship.
Get an injunction from the civil court.
Subsequently, that time I have not filed any injunction petition before the court. And subsequently, after that civil case has been filed before the honorable learned civil judge.
All right, so get us the injunction order from there. No restraint from entering into your property that the civil court will do. This is just frivolous, absolutely. Do you want to say anything else?
Separately different aspect of the
Yes,
matter.
yes.
Not the purely civil and criminal. That was the different aspect
Very well.
where I will go for against
There
the government officials.
There is a hierarchy of courts provided in CRPC and in CPC. You can approach any court which you desire. Writ is not the appropriate jurisdiction, madam.
state or instrumentalities of the state.
Yes. So why can't they be prosecuted for non-performance of duties? There are provisions for that also. Okay, very well.
Where the writ lies also.
Yes,
Against the inaction or action of the government official, the writ lies, Lordship.
yes, all right. Read your pleadings. Who is responsible for the inaction? Read,
I have stated that respondent number 13 and
read your, read your pleadings in the writ appeal, please.
in the petition.
Yes. Page number.
Page, page 60, Lordship,
Yes, read.
paragraph 16.
Yes. Yes. So you are aggrieved by the registered sale deeds executed in the year 2006. File suit for cancellation if you are aggrieved by that.
I have filed.
File a suit for cancellation, madam. That is the remedy. Your,
I have filed-
these registered documents were executed in 2006. You file a writ petition in 2013. After 7 years. What kind of invocation of writ jurisdiction is permissible?
That time we have not
Sorry.
received any of the deed inside the, that's why we filed for a certified copy. In 2012 also, we have received a copy.
Yes. So 2006, you came to know when about these registered sale deeds in the year 2006 itself, as per your own pleadings.
Yes,
And you approached the writ court in
but
2000.
we have applied for the certified copy.
All right, we
have
are not
received
satisfied, madam.
anything.
We are not satisfied. Thank you.
Lordship.
Dismissed.
Matter number 8 for order on interim application.
Yes.
May I
May I
please-
please have lawsuit? In this case, lawsuit, my learned senior friend has filed an interlocutory application for modification. We want to file a short reply lawsuit. Lawsuit may kindly allow us 2 weeks time for.
2263.
Lawsuit.
2263 will not apply because I was also there. ma'am.
You are heard.
I was.
So you want a modification of stay?
Modification, my lord, the issue is like this, their promotions were assailed by me. The honorable single judge interfered with their promotion and said that a fresh exercise would be covered.
Right.
This, my lord, they put it on appeal.
Right.
On the first occasion when the appeal was moved, my lord,
Yes.
this honorable court said that the promotion exercise can go ahead. That my lord would find at page 51. The promotion exercise can go ahead and that will be completed. And in the meantime, they will continue to hold the post.
Yes.
Then they file an IA, my lord, separate IA.
All right.
And in there, they prayed, my lord, that the page 46 is the prayer, my lord,
46.
46, my lord.
Just hold on.
That
So just hold on, Mr. Nair. The first order is 23rd January 23,
lordship,
right?
lordship.
Then the IA comes up on, IA is at page number,
IA, my lord, it starts at page number 30,
what is the prayer in the IA?
prayer at page 46, my lord.
Mhm.
They wanted a modification only to the extent that selection process should go on, allowing the present applicants to participate in the said
Result
selection.
of DPC should not be published.
Published.
Yes.
Now, the order that was passed, my lord would find at page 55,
Mm.
after the main pleadings, my lord, the objections and all, my lord may come to 56, para 4, my lord.
Mm.
If two vacancies are available in the cadre of assistant executive engineer submitted by Mr. So-and-so, there should not be any difficulty on the part of the respondent authorities to consider the case of the present respondent number 7 for promotion to the post of assistant executive engineer during pendency of the appeal. We are of the view that in the interim, since the respondent number 7 to 11 and 13 to 17 in the writ petition are still holding the post of assistant executive engineer, they may be allowed to hold the same. So, my lord, they were removed. Then, my lord, this honorable court in the interim order permitted them to continue till that exercise is complete. Now, my lord, although there was an observation that my case also for promotion to that cadre be considered, now they are not considering and they are continuing in perpetuity, my lord.
The DPC has not been
No,
convened.
my lord, because this order, because of this order, the DPC is not convened.
No, this order doesn't say that the DPC will not be convened.
But because, my lord, of this order, that they will continue to hold the post.
As an interim arrangement.
But the clarification is not there. That's why I'm before your lordship. If the DPC is held and it's
Yes.
taken to its logical conclusion.
Who is for the state?
My lord, my friend, pollution control.
Yes.
I'm for the board.
Yes. Why the DPC is not being held?
In fact, the entire challenge is with regard to whether the appointment of the present appellate is
Gentlemen, there is an order dated 23rd January,
Yes.
which says that the DPC shall be convened. The result will not be declared without leave of the court.
Yeah.
Why your officers have not convened the DPC?
After that, another IA has been filed by the private.
Read the order. Does it restrain the proceeding of DPC?
If I go to the last, the
Yes.
Page 56.
We also make it clear that all these appointments and arrangements made in terms of order passed by this court today.
I would like to read the last order in the
Yes.
IA with
Yes.
on the relevant portion.
Yeah.
Uh, Let me read from the second paragraph. With this matter was taken up today, it has been submitted by learned senior counsel for the appellant that though this court-wide order so at 23/1/2023 passed in WA has given some interim protection in response number 7 to 8 and 13 to 17 in the writ petition, they have not been allowed to hold the post of assistant executive engineer till the process of fresh promotion to the post of assistant executive engineer is completed
Yes.
by the authority in terms of the direction of the learned single judge. He submit that it may also be directed that even if the said promotion process is completed, it may not be given effect to without leave of the court, and they may be allowed to continue to hold the post of assistant executive engineer till the disposal of the writ appeal. The said prayer has, however, been objected by Mr. Nair, the senior counsel for the present respondent, that though this court directed the authority may consider the case of the writ petitioner in the appeal, which will be subject to outcome of the appeal, the authority are not proceeding with the promotional process. According to him, there are two posts available in the cadre of assistant executive engineer, to which the writ petitioner can be accommodated in spite of earlier order passed by this court protecting the service of the respondent number 7 to 11, 13 to 17 of the writ petition. If two vacancies are available in the cadre of assistant executive engineer as submitted by Mr. Nair, learned counsel, there should not be any difficulty on the part of the respondent authority to consider case of the present respondent number 7 for promotion to the post of assistant executive engineer during the pendency of this appeal. We are of the view that in the interim, since the respondent number so and so in the writ petition are still holding the post of assistant executive engineer, they may be allowed to hold the same. We also make it clear that all these appointments and arrangements made in terms of the order by this court as well as on 23/1/2020 in writ appeal will be subject to final outcome of the appeal.
Right.
Yes.
So where is the?
Yeah, it has, entire order has been passed based on the submission of Mr. Nair that there are two posts of assistant executive
Right.
engineer which are vacant. But entire challenge is with regard to whether the appointment, the promotion and upgradation of the private respondents are right. And for which they have already lost in the single judge and they have filed an appeal.
Yes.
Till the time that appeal is not decided, that point has to be finally decided in the appeal. So that is the
Gentlemen,
core issue which has to be
The
addressed.
order dated 23rd January stands. You have not sought for any modification of that. How can you withhold the DPC? Let us know. On what premise can you not proceed with the DPC? Is there any modification to the direction whereby DPC was ordered to be convened?
In fact, for that 23rd order, we haven't come before any modification, only
So-
the private respondents.
But there is no modification, only an interim arrangement, they may be allowed to continue, but the DPC has to be held.
Yeah.
Then what is the confusion? Hmm,
Okay, in fact, okay, that modification we have prayed for.
there is no modification as such, sir. The matter comes upon his application, not your application.
No.
Your modification, whatever you asked for, the court has already given. On this order is 4th February,
Three.
No, it's not
3-2.
Yeah.
That was your application.
Yes.
Yes, so whatever modification this court wanted to make, it has been given, but there is no modification on the direction to convene the DPC. How can the state officials withhold that?
And also it was also direct.
Should we initiate suo motu contempt then?
No,
What do you want?
Lordship, in fact, Lordship, if at all, for that matter, again, we have to go back to the single judge's order. So single judge's order says that their promotion has been set aside and quashed.
Yes,
That said, after this setting aside and quashing of those orders,
gentlemen,
the private respondent has come before the learning
Yes.
division bench.
so there is
So,
no stay on the setting aside of their promotion. Their interim arrangement as they were working on the post of assistant executive engineer, that has been saved. That doesn't give them any right of consideration. Right of consideration is available to respond number
That
7.
will be subject to the outcome of the
Yes,
writ appeal.
so you convene the DPC, keep the result in seal cover.
That-
What is the problem?
That we can do. But
So
there-
that
there
is
was
what
a-
the order is.
There was slight confusion because of the subsequent orders being passed one after another in the IAs. So at least DPC, we can very well do it.
Mr. Nair, why don't you argue the matter finally?
I'm ready, madam.
All right, argue.
Lordship.
Forget about the modifications. Come on. Yes.
So I'm led by senior advocate K. N. Sodri Lordship. So today also I was seeking time to file a reply to the interlocutory application.
Let us order be fixed.
Lordship, already Lordship has fixed.
Argue it finally.
Lordship already
My
has
lord will
fixed
fix
it
it.
for
I'll
admission
agree.
after 4 weeks.
That is better, my lord.
Not for admission. We'll dispose it of finally.
Lordship, my lord will fix it.
Why unnecessary it is?
No issue, madam. I'm ready.
All right.
That would be the best course, madam.
On the request of learned counsel for the parties, while keeping the interim applications for modification of ad interim orders pending, it is hereby directed that the writ appeal shall be taken up for final disposal at admission stage on 3rd May.
Lordship.
3rd May.
Lordship.
All right.
Item number 9 for fresh admission with stay.
Yes.
Yeah, Mr. Lord. Yes, writ appeal, my lord, has been referred against the order dated 9/9/22. What we will landed single judge, the lordship will find the order is page 102.
Yes. One post has been reserved for ladies, female,
Yes,
as per 30%.
Yes,
What is wrong in that?
my lord, I'm not challenging that, my lord.
Then-
My grievance is that, my lord, I was absorbed after serving as additional member.
Hmm,
And thereafter taking interview, I was appointed into the 16 on regular basis.
yes.
And there was also vacant post. The honorable division bench in rate appeal directed that from the pool of women reservation post, the private respondent should be appointed.
Hmm.
And if not availed, then anyone may be replaced.
Yes.
So, my lord, I've been replaced without
Gentlemen, the post reserved for ladies for a female cannot be filled by a male candidate. That is a settled position of law.
Yes, my lord, but
Yes.
my grievance is that, my lord,
It may remain vacant, but it can't be filled by a male candidate.
my grievance is that, my lord, since there was a vacant post at that time, and directly the honorable division bench, not
directed that I should be replaced. My lord.
Which is the division bench order?
Your lordship will find division bench order at page 77. my lord.
77,
No, my lord, page 86. Sorry, my lord.
6. Read. Yes,
Operative portion, your lordship will find page.
this is
91.
in the rate of the respondent, private respondent.
Yes, my private.
Yes,
Page 91, my lord.
yes. Hmm,
That is para 20, my lord.
yes.
To fill up the seat vacancy as per merit from the pool of women candidates, my lord.
Hmm.
So, and if in this process, any of the selected appointed candidates, including the 7 to 9, has to be dislodged, that should be put on notice, whether.
Pool of Indian women candidates.
Yes. my lord.
Yes.
So, my lord,
So
at
it,
that,
it had to be filled from a pool of women candidates. A male candidate could not have been appointed against that post.
so, my lord, it is not certain that whether I have been appointed against the female candidate or not. On that ground, my lord, that was not decided. No, fortunately,
could-
nothing.
You were represented in that appeal. You were respondent number 7.
Yes, yes, my lord.
So you could have challenged that order. The order clearly conveys that if you are to be dislodged, that process will follow. You have been dislodged. If you are aggrieved of that, then you should have gone to the Supreme Court.
So, my lord, my humble prayer is that, my
Yes.
lord, there are also, my lord, vacant posts, my lord. I may be adjust in any. because I
If
am
there are vacant posts, they will
selected-
be filled as per the procedure provided in law, in rules.
But my lord, at this.
Where is the
point-
question of
at
adjusting
this
you?
point of Time, my lord, I am overaged, my lord. That's why I am, my lord, 52 years of age. So after serving more than 20 years, my lord. So abruptly, my lord, due to the fault of the department, my lord, no, in the advertisement, your lordship
You had
will find-
served, when was the advertisement issued?
Advertisement was.
2014.
Yes, my lord,
So by till that time, you were already serving on the post.
16, my lord, 16.
You were
16,
serving
my
on
lord,
what post?
Find that page 77.
You were serving on what post at that time?
At that time, I was serving as Mondal, my lord, Mondal, post of Mondal, not Mandal.
So this is again a recruitment for the same post.
Yes, my lord, earlier it was additional Mondal,
Hmm,
not regular post,
right.
and thereafter it is.
So the vacancies were advertised. You were wrongly selected against a post which was supposed to be reserved for women. What right do you have to apply for that post? Let us know. There were only 6 vacancies. When the the red petitioner is appointed against the 6th vacancy, there are no more vacancies. How can there be a supernumerary post will be created for you or what? Against which post will you be appointed?
My lord, Nilima Rai, she was the only single candidate. She
Yes,
also could not qualify. She got only 17 marks.
all right.
Yes, my lord, she on merit.
But irrespective, tell us some judgment of Supreme Court which says that posts reserved for women can be filled in by a male candidate. Let us know. It will remain vacant to be filled in the next recruitment. That is what the law is.
So my lord, there is a, due to the wrong of the department, my lord, I am victim.
What is wrong? You were given wrong appointment. You enjoyed salary for a particular period of time. Remain happy in that.
My
That's all.
suggestion is that in the advertisement, no, there should be re-advertisement. You know, in the advertisement, no post has been reserved for the woman candidate.
All right, the court
If
rectified
would
it.
have been done,
Mr. Counsel, we are not in review of that division bench order now. That order has attained finality. It was not challenged any further. Now what right remains with you?
In my read petition, my prayer was that, my lord, I may be adjusted against any vacant post.
Which vacant post, sir? You can't be, any vacant post will have to be filled as per law. It can't be randomly done at the whims of the authorities or at the whims of the court. Vacancies have to be filled in as per law, as per rules.
Yes, my lord, as per
Then-
rule, I would have given the opportunity to contest by condoning my age, my lord, by considering my experience. So,
Sir, that prayer you had to make in the earlier round of litigation. Now you can't do it. Sorry. Yes, what do you say?
May it please your lordship. I am appearing for respondent number 4, lordship. In earlier round of litigation in read petition as well as in the read appeal, your lordship. Notice was served, he did not contest it, lordship.
You did not contest.
No, lordship.
He did not
Appellant-
contest,
appellant
yes.
Did not contest.
Yes.
And it is very much reflected in the affidavit in opposition filed by the government in the present writ petition, Lordship.
Writ petition or appeal?
Present writ petition, Lordship.
What page? Page number?
Page number 74, Lordship.
Yes, read please.
The relevant portion, Lordship, page number 74, last paragraph. It is stated that the petitioner, Sri Pratap Chaudhary, had also attended the interview on 7/2/2016 and had secured lowest marks amongst the 3 unreserved appointed candidates. As such, in pursuance of the order dated 2/1/2018 of Honorable Guwahati High Court, Guwahati in writ appeal number so-and-so,
Yes.
a notice by number so-and-so was issued to Sri Pratap Chaudhary, Miss Mondal, Mankachar Revenue Circle, asking him to show cause as to why he should not be dislodged from the post of Miss Mondal appointed from the unreserved category in the light of advertisement number so-and-so. And accordingly, Sri Pratap Chaudhary, Miss Mondal had submitted reply of notice, reply show cause notice issued to him. And the same was rejected by the Deputy Commissioner White, order dated so-and-so, dated 25/7/2018, Lordship.
Yes.
That was also not challenged by.
That
the
was not
court.
challenged. All right.
And
No, your appointment could not have been questioned. That was in terms of the division bench judgment.
Lordship, and he had been dislodged from the post of Miss Mondal, and in his place, Srimati Nilima Das, wife of so-and-so, has been appointed.
And there is no pleading in that writ petition, earlier writ petition or appeal, that any other post is lying vacant where he could be adjusted.
Lord.
All right.
My lord, learned,
Yes.
there was an observation by the learned single judge.
Yes.
Petition that my case.
Mr. Counsel.
May be considered.
It can't be considered, whatever posts are vacant, they have to be filled in as per law. Why you are to be given precedence? What is the reason? It's not a case of regularization of temporary services. It's a case of substantive appointment that has to be done as per rules. Thank you. Dismissed.
I'm deeply afraid.
Matter number 11.
May please, Lordship, this is a challenge the policy, it is a single bench matter. It is longly listed.
It's a single bench matter.
Challenge the policy, therefore.
Then council submits that is challenge has been given to
Policy dated 28/9/2000.
the policy dated 28.
28/9/2021.
That's annexed. Where is that policy?
Yes.
In a policy and not to any statutory rule or provision, comma, the matter is required to be heard by a single bench. The registry to office to make a report on this submission. You challenge an OM to make a report in this regard and shall list the matter before the appropriate bench. Let the registry make a report.
Matter number 27 of supplementary list.
Mr. Nair, do you feel any advantage in today's system of listing?
Yes,
Is there more clarity?
clarity is there.
This is what we have imported from my parent high court.
It's.
So I was finding it very confusing actually.
Oh.
Under
Oh,
what
dear.
head the case is coming up?
No, my lord, at least while going through, my lord will know what is the.
Precisely
nature-
under what category the case is listed.
It's a good move, my lord.
Yes.
My lord,
Yes.
in short, if I may just give my lord a gist of what was my grievance before the honorable single judge.
Yes, please.
My lord, whatever is there is correct. Whatever the honorable single judge has said is correct. Only thing he failed to appreciate was that
Yes.
I was the regular headmaster and the other person was a person on in charge, FR 49C. Now, what had happened was, my lord, my school was a madrasa. Both the schools were madrasas earlier. The earlier other school, which is my lord B school, was my lord provincialized much earlier. And my school was provincialized in 2013.
Right.
Therein, I was the my lord principal in my school. As madrasa, I did not have a B.Ed, but in the madrasa education, that was enough. My lord, the government takes a decision. All the madrasa institutions are converted to normal schools. And that policy says that what we are converting them, they will come under the new rules of 2018, but their status, pay scale, seniority, etc. will not be disturbed.
Changed.
So I am a headmaster. Because of that, my lord, I was the principal, but I became a headmaster and I continued. Now, these A and B schools, my lord, are in the same campus. And these schools were directed to be amalgamated.
Right.
In the
Merger.
first round,
Yes.
school B was amalgamated with school A.
Mm.
And my lord, nobody had any objection, but the principal headmaster, in charge headmaster, he raised a grievance before this honorable court.
Mm.
This honorable court, on examination of the matter, remanded back the matter to the director, saying that he will file an appeal, you take a call. Director, my lord, issues notices. The inspector of school submits a report. Rightly so, my lord, says that I don't have the qualification of BM. Fine, my lord, I have no dispute on that.
Mm.
The other person has.
Yes.
I submit a written statement and therein I highlight one point that, see, I am the regular headmaster and he is on in-charge basis. Because on amalgamation of the schools, my lord, the law, the requirement is, if there are two headmasters, the senior of them, either of them who is senior, would be the headmaster of the new amalgamated school.
Irrespective of the fact that the senior doesn't hold the qualification.
My lord, because I have already, because this is, my lord, that amalgamation thing is in respect of the normal schools, my lord. I have come here because of the conversion of my school.
Madrasa into a normal school.
Lordship?
Madrasa into a normal school.
Normal
Yes.
school. And
Yes.
not the law.
But does that give you
Yes,
a
yeah.
right to
Right, because-
claim certain benefits
My
or a
lord-
position without being qualified?
My lord,
for?
I'll
Ask your client to get that qualification.
I'll try to justify that, my lord.
Yes.
If the other person, my lord, was a qualified headmaster, regular headmaster, and then, my lord, this issue would have arisen, then, my lord, I may not have had a case, my lord. There is no regular headmaster there, my lord.
Irrespective, for the post of headmaster under the new set of rules, is the respondent qualified or not?
He is qualified.
Then
He is qualified.
closed.
He is qualified. But if your lordship just.
If there is a choice to appoint a headmaster from two persons,
No, no.
one of
No,
whom,
no, no,
just hold on,
Lordship.
one of whom is qualified and the other is not,
my lord, yes.
what decision would be taken?
I bow down to that.
Yes.
But here the situation is, my lord, I am a regular headmaster, maybe not qualified,
The regular headmaster under the erstwhile provisions.
but it has been protected.
Protected, subject to the persons holding qualifications,
But-
not randomly, not contrary to rules, not dehorse the rules.
But,
Yes,
my lord, in the B school,
yes.
he was not the headmaster.
Maybe there are two persons available
No,
who can, he was in charge,
he was in charge.
so you were holding the post of headmaster, but under the changed circumstances, you are not qualified,
Lordship.
What right do you have?
That's
They
My lord, they come
only,
to page
Yes.
64, my lord.
yes,
The order by which, the policy by which the conversion was made.
yes,
Page 64, my lord.
yes, please.
My lord can leave everything else. Roman 2 para B,
Yes,
the existing staff, both teaching and non-teaching of the madrasa educational institution, which are governed under the rules mentioned under clause 1 above, shall be governed under the so-and-so with effect from the date of commencement of this notification. And their conditions of service shall continue without any change in their status and pay.
yes, all right.
Then, my lord, would come to the notification 12 to 22, page 65, it starts.
Yes.
I'll have my lord's attention at page 66,
Mm,
down below, my lord, clause 4.
yes,
The administrative control of the madrasa institutions, including staff, will remain with the education department as before. There shall not be any change in the status, pay and allowances, service conditions, etc. of the teaching and non-teaching staff.
teaching and non-teaching staff.
Yes.
So not of the administrative head.
My
This
lord,
doesn't deal with the administrative head.
The principal or a
Yes.
headmaster,
Yes.
he comes within the fold of teaching staff. My lord.
That's all right. But this is something different. Who is to be given the drawing and disbursing power? A
No.
person not qualified. How he can be given that?
My lord, I have been working as a drawing and disbursing officer from 2013 on.
Under the old rules, under the old set of rules.
My own.
There
set
the
of-
qualification was not required.
Lordship.
So now there is a change in qualification. Ask your client to upgrade himself. Get the qualification. There is no limit to,
No,
no
my
age
lord.
limit for
No, no.
getting
He's
a
only, he's a
qualification.
very young man, my lord.
Yes, then,
Young man. And now my lord would see the direction issued, my lord,
yes,
at page 62, my lord,
yes, please.
the last paragraph, my lord.
Mm,
Since there is a dispute regarding holding of drawing and disbursing officer after amalgamation of said so-and-so with so-and-so, after hearing the learned counsel for the parties and considering the effects of the matter, the court hereby directs the director secondary division to pass necessary order in that regard after determining the seniority of the petitioner vis-a-vis the respondent number 6.
Yes.
Considering the requisite
Requisite eligibility.
So and
So,
so,
Mr. Nair,
Lordship.
is the requirement of eligibility criterion diluted by the provisions which you have pointed out at 64?
My lord, when they.
Is it
have convert-
diluted?
My lord, when. they
What
have
is the,
con-
what is the eligibility criterion for post of headmaster?
You must be a B.Ed, my lord.
All right, so whether these rules, this notification dated 12th February 2021 overrides the provisions of the rules?
Lordship. My lord, if I may answer to that.
Yes,
A person, my lord, who wants to come into that post of principal or headmaster after 2019, my lord must have that qualification. My lord will envisage a situation, my lord. If they want to get recruited to that post, they must have that situation. My lord will envisage a situation prior to 2019.
qualification would not be for a fresh recruitment. Qualification would be for the post.
For the post.
There is no saving, no saving clause which says that a headmaster's post can be held by a person. If that was the intention of that transition, then a specific provision would have been brought in. That even if the headmaster who was working earlier is not having the qualification, he will continue to do so.
My
There is
lord,
no such
if
specific
I may
provision.
just point out one thing, my lord.
Yes,
These rules came in 2019.
yes,
Now, prior to 2019, my lord, in a normal school, there is a person who fulfilled the conditions of the post as on that day.
yes.
He is continuing. New rules come in, it cannot be applied to him because he is already an existing incumbent in that post, my lord. The new rules, my lord. No, the
If-
new
if
rules, my lord, are
There
rules for
could not have
recruitment.
been a situation in a normal school wherein a principal or a headmaster could be appointed without having the B.Ed degree. That is for sure. In normal schools.
Normal school.
Madrasa only gave that leeway. So
Madam-
we can't equate those two situations.
My lord, I'm not on that. I'm trying to put across another point. my lord.
Yes.
What I'm trying to say is, my lord, say there is a new set of rules coming in 2019, which,
Mhm.
my lord, is the 2018 rules. It came in
Yes.
2019. Prior to that, my lord, there were recruitments to the post of headmaster. Wherein
Yes.
these requirements were not there.
Yes.
In a normal school. And a person gets recruited.
Yes.
He, my lord, continues. With the
In that,
application-
if there was any intention of the legislature to save those persons in the same position, then a specific provision would be created.
My lord,
That irrespective of qualification, these persons would continue.
why I'm saying so, my lord?
Your
Because my
salary is,
pay-
your salary is prevented, you should feel happy about that.
My lord would look at that also. I'm being deprived, my lord. My lord would see a clause in the amalgamation order.
Yes.
I'll just conclude with this, my lord. My lord may have page, it starts at page 34. I'll have my lord's attention at page 36, my lord.
36, all
Lordship.
right.
15A, my lord.
15A, yes.
My lord, these two schools have become normal schools. Now the amalgamation is taking place.
Mhm.
Further, the following condition, including service condition, employees shall apply after the merger. The school having good infrastructure facility together with an amiable academic atmosphere and proper road connectivity in comparison to the other school shall be the base school and the other school shall be merged with that base school.
Mm.
The senior most principal headmaster shall be the principal headmaster of the school after the merger.
Mm.
If the date of joining happens to be the same, then the seniority in age shall be taken into consideration for determination of that seniority.
Mm.
The other principal headmaster shall be the ex officio principal headmaster
Mm.
with the post personal to him, and she shall continue to get his pay in the existing status
Mm.
till retirement or posting elsewhere.
Mm.
Now, when the first school was, my lord, amalgamated, if my lord can have the order at page 41,
Yes.
the first round of amalgamation, when that school was amalgamated with my school, my lord, page 41, relevant page 42, serial number 10, my lord.
They are of the same category, both schools,
No, my lord, both were madrasas.
madrasas.
I was a title madrasa, it was a senior madrasa, my lord.
Where is the provision regarding merger of madrasa schools?
My lord, it's not there. This is, my lord, with regard to after the conversion was in February, this office memorandum comes in August 2020.
Mm.
Now, my lord comes to page 41.
Mm.
That is the first round of merger.
Yes.
Here, my lord, page 42, serial
Yes.
number 10, my lord.
Mm.
The treasury officer, Hailakandi Treasury, the headmaster of Jamira Hut school A, which is my school, will be the DDO.
Yes.
Initially, my lord, I was made the DDO. Then, my lord, he comes up with a writ petition. Therein, my lord, the matter is directed to be remanded back. The same way the authorities now take a contrary view, rightly so, my lord. That facts I cannot dispute. And then, my lord, the second order comes, which my lord would find at page 52. Now,
Yes.
the base school becomes school B.
Yes.
And school B becomes the base school, page 52, 53, serial number 10. The other in charge headmaster, he becomes the DDO. Well, if he is appointed on regular basis, my lord, I have nothing to say. But you have,
Qualifications.
by fiction, you have brought me,
Mr. Nair,
lordship.
by virtue of his qualifications, this fiction has to be created.
My lord, I would have,
Simple as
I would have been happy.
What has happened after direction
But
of
after this, my
considering?
lord, after this, the matter was to be considered by the director. Till now, consideration has not
So
been made
let
because
let us call upon them to decide the issues.
issues. And
What has
lordship, the
happened,
other- come on, salary kitty. And from February onwards, my lord, because of this, my salaries are not being released, my lord.
Yes, all right, issue notice. All right, issue notice, Mr. Your good name, please. Mazumdar appears for the respondent senior secondary department
1 to 4.
1 to 4. 1 to 4? 1 to treasury, you will not be appearing.
No, 5, my lord, 5.
1 to 5. Treasury. 1 to 4. Mr. So and so appears for the spot number 5. Notice the issue to the spot number 6.
Lordship.
Rule is made returnable in 6 weeks.
Lordship.
Mr. Nair submits that the pursuant to the appointment of the respondent number 6 as the principal headmaster of the amalgamated schools, the salary of the appellant is not being released. Full stop. Shri Mazumdar shall look into this matter. Rule is made returnable on 17th May.
My lord, he has not been made the headmaster. He has been made the DDO, my lord.
Who did you?
DDO. Much obliged.
Item number 12 and 13 of daily list for fresh admission without stay.
May it please your lordship. In this case, my lord, the item number 13 and
Yes,
12, my lord, are out of common judgment, my lord. 13 was long back, my lord. it was
admitted. So
admitted,
you
it
want
was
this,
released.
this also to be admitted?
This is admitted and my lord, list for hearing, my lord.
All right, admit issue
The
notice.
first week of November.
Respondents are duly admit, respondents are duly represented. Thus, notice need not be issued. List for hearing along with writ appeal number. Hearing in due course along with writ
Due course,
appeal.
my lord, due course, my lord. So many times the matter was heard, my lord. Can you do, if it is not inconvenient to your lordship, first or second week of May, my lord, any day?
List for hearing in second week of June with connected writ appeals. There's only one appeal, or there are more appeals?
Only 2 appeals, my lord.
Only
12
two.
and
Writ appeal number 168/2019.
All right.
Item number 15.
Yes.
My lordship, the lordship, the petitioner before this honorable court is the actually financial institution.
Hmm.
My lord, we have taken the assignment agreement with the Indian Overseas Bank in
Hmm.
respect of the loan taken by the respondent number 3 to 8.
As per you, the district magistrate is not taking
Not,
appropriate steps.
yes, my lord.
So why does this writ come to division bench?
My lord, I'm not aware because this is matter is relating to the.
No, this
surface-
is the matter,
surface
not,
matters concerned.
in this you simply seek a direction upon the district magistrate. There's nothing to do with the Surface Act as such.
My lord.
Rupam, ask the registry to check the prayer, by virtue of the prayer, this should not come to DB. It's a single bench matter. The registry is directed to examine the matter with reference to the prayer made in the writ petition and list the case before the appropriate bench.
Develop.
Matter number 17 for admission with notice served.
Service completed, my lord.
Before my learned friend begins, Lordship, I'm appearing for aspirant number 6, Lordship.
Yes.
Lordship, today I have received a copy of additional affidavit,
All
Lordship.
right.
So I need some time to take
MS fine.
instruction.
So what's your good name, madam?
A Devi.
MS A Devi appears for the respondent number 6. She submits that she has received copy of the additional affidavit filed by the appellant today and needs some time to peruse the same and file counter if so required. Counsel for the petitioner. Appellant has no objection to the prayer of MS Devi, A Devi, thus list of 4 weeks.
Obliged.
Date may be fixed.
Pleadings be completed in the meantime. List on 22nd May.
My lord.
Obliged.
Matter number 18.
Here I appear for respondent number 3, my lord. I have received a parawise comment, my lord, regarding my lord various financial.
You were to file affidavit last date.
Yes, my lord. In fact, it is not adequate, my lord. I have instructed them to furnish further instruction, my lord. The
On previous
allegations are
date,
serious.
Learned Advocate General was appearing.
Yes, my lord.
So you are appearing now.
My lord, after filing of the affidavit at the final hearing, he will appear.
All right.
Otherwise, my lord, the
Mr.
instructions. are not
Counsel,
adequate.
you are Mr.
B. Gogoi, my lord.
B. Gogoi appearing for the respondents.
Yes.
Submits that some more time is needed to file a detailed affidavit in
Lordship.
response to the government's made in the red petition.
Right.
He prays for and is granted 4 weeks time to do the needful. List on 22nd May.
I'm obliged, my lord.
Matter number 19 to 21 for final disposal.
May I pleasure your lordship? Lordship, just today only we get the records. So sometimes maybe granted.
There was an order passed by the lordship, will also recollect.
Record is here.
Record is there.
Yes. So you want to inspect? Do you want an
yes.
opportunity of inspection?
One day.
We can permit you to do so.
Record is not there, he said.
You just now said that we have received the
In the office.
In the office.
in the,
Office of the government advocate.
so all right, you can, we'll permit you to inspect if you so require. Hmm.
Yes. Only to the extent about regarding what. How
What
they have
proceedings,
dealt.
how it went to
How
the,
proceeding
so
is
basically
concerned.
the
How
court,
proceeding is concerned.
court has to see you, where are the records?
The government office. Government office. Lordship,
So should we send a peon to get the record or what? Then you are supposed to be here with the record.
Lordship, we just want to go through the records and.
They want to go to the record. They have not gone to record.
In that case,
All right.
lordship, the matter may be
Just-
taken up immediately after vacation. Your lord.
This is not a vacation, gentlemen. This is a
No,
break.
not a Holiday. Holiday.
It's a break. It's a break. All right.
Bihu break, your lord.
And government council so and so submits that record has been received shortly herein before and that some time is required to go through the same. Let's re-notify on 27th April.
My lord, we will be a liberty. My junior will go and also.
It
We
required,
don't waste,
The appellant's counsel shall also be permitted to examine the records, inspect the records as and when requested, as and when desired.
Deeply.
Deeply obliged.
Matter number 22 for hearing.
Lordship, I have the instruction not to praise this.
Yes, better advice.
Yeah.
It's good advice, we would say.
Lordship.
I was going through the file.
Yes, Lordship.
This is now part 2. We have started listing.
Right.
And Mr. Kalita, and Advocate General Mizoram, submits that he has been instructed not to press this appeal in view of the submission so made, the instant intra-court rate appeal is disposed of as not pressed.
Yes, observe.
No order as to cost.
Lordship.
Observe.
Matter number 23 to 25.
Mr. Advocate General has had the time to go through the records
I have
despite the
gone
IPL and everything.
I managed to go, but this is one situation where I'm totally at loss.
Totally
Because two reports has come whether there is a pending inquiry against the officer.
Mhm.
The commissioner report says that they did not proceed any further. The other part, the director said, we lost an FIR, but we sought the approval from the government and government till date for 6 years has not granted the approval. So in that situation, whether there is a pay scan, in the FIR, he is not named also.
Naming is not very relevant.
Yes, Lordship.
Naming is, but
Naming is not relevant. Another aspect is very relevant, Lordship.
mm,
He was not a jurisdictional
we
authority.
don't find Mr. Chaudhary here. Mr. Ken Chaudhary was representing the respondents.
Yes, Lordship.
He's coming.
He's coming. All right. Yes.
He was not the jurisdictional authority. He was specially engaged at one point of time.
Mm.
And he found that lot of anomalies were there while bringing the vehicles. He did his inquiry and come to a conclusion that this will be the best assessment amount.
Mm.
Against that, the SSC went to the tribunal.
Mm.
Tribunal found that whatever was granted, it was correct.
Mhm.
Then another officer reduced it.
Okay.
That was also negated and the tribunal upheld the order given by Rakesh Agarwal.
Okay. So
That went
basically,
to the division bench.
this complaint or FIR is in relation to the quasi-judicial.
Quasi-judicial authority, which is not,
proceedings.
he is not empowered. He gave an order that all the officers who dealt with Ghosh Brothers from 2004-5 to 2016-17 should be inquired.
Ah, okay.
And that order, which was upheld by him, he himself is the person. So that went before this division bench,
Mm.
and division bench found there was no anomaly and directed recovery of more than 40 crores, which we have done.
Okay. So probably
In
out of
fact,
vengeance-
Lordship, here the complete, Lordship, in fact, he is entitled for a reward actually. This Rakesh Agarwal. This is the position. And the law is very
Yes.
clear, 2010 Act, Lordship, does not empower the Vigilance Commissioner to
But then
direct,
the
and
government-
he himself appointed an
government
officer.
Why the government was sitting tight on it? It could have concluded the proceedings. This has created a situation, no doubt.
Yes, Lordship.
That pendency will reflect. There is no doubt.
Pendency will reflect.
Pendency. So why the government was
But
sitting tight?
Again, that approval was never granted.
Irrespective.
And
It's only an allegation is they can hang on to that the thin thread
Yes.
pendency. That is
Yes,
what the argument
that
is.
exactly, and that was not the case before the learned single judge also. I have gone through the whole writ petition. It is offshoot now.
That's all
And
right.
one more aspect, Lordship,
Yes.
the commissioner directed that necessary orders should be passed to close it because an opinion from the Advocate General at that point of time was sought. In fact, for 2 months, my opinion was a part of the record also. Under the act, there is no authority of the Vigilance Commissioner to direct and appoint an officer.
Okay.
He has violated all norms.
The CVC.
Yes.
Okay.
State
State
Vigilance Commission.
Vigilance Commission. Okay. Mhm.
I can place complete
But
record.
why don't you bring these facts on record through an affidavit?
I would like to,
Then
Lordship.
they will, if they want to respond, they can do it.
Yes, Lordship.
All right.
In fact, the opinion also I would like to place because on the
Yes.
opinion that was sent to the director to close it.
Do that. All right. Because then it's a case wherein some persons with some vested interest might have stalled the decision of the government. That's quite possible.
Quite possible. And one very important file is still untraced from the person from 2019 onwards.
All right. But otherwise also we have completed the board. What to do, gentlemen? Yes.
They may bring up record for the
All right. Then Advocate General submits that he has received
Only on this point, Lordship.
detailed instructions regarding the allegations, government's assertion made on behalf of the respondents regarding pendency of the vigilance inquiry against the appellant, and that he shall bring the same on record by way of an affidavit. Let the affidavit come. The needful, the affidavit be filed within
Lordship, in the first week of May, let it come.
within next 10 days.
It will be a little bit difficult. By last week of this month, I will file it.
On or before 28th April,
I will file it.
a response thereto, if required, be filed on behalf of the respondents by the next date of listing. re-notify on 8th May.
It could be little earlier, my lord.
All right, 4th May.
Highly obliged, Lordship.
Yes,
Item number 1, leftover matter.
Lordship, I have received the message that his father-in-law, council father-in-law has expired. Therefore, he
who's
will not-
council's father-in-law?
Lordship.
And council, it is stated that the appellant's council has suffered, respondent, council for the respondent has
Lordship.
suffered a bereavement in the family. In view of the submission, so made, come on, let's up 2 weeks. Date down in 2 weeks, Patki. Give a date of 2 weeks. Then what about the supplementary 27? That has already been taken up. All right. Yes,
May,
yes,
can they have a look last one?
yes, yes. Mr. Government Council,
Yes, Lordship. Lordship. His
just
matter was-
first understand one thing.
Yes, your Lordship.
If the order which is under contempt
Yes, Lordship.
has not been challenged, has not been stayed,
Yes, your Lordship.
then your officers have to be told,
Yes,
come with the compliance report
yes, Lord.
on the first date.
Yes,
We will not grant you 2 months, 3 months time.
yes, Lord.
Just convey it to your officers. Otherwise, they'll be lined up here
Yes, Lord.
each day, day-to-day basis.
Yes.
What have you done this? in
Here,
this case?
Lordship, his matter was placed before the state level scrutiny committee, Lordship,
Hmm,
and the hearing was conducted on 23/2/2023, Lordship.
hmm.
Thereafter, Lordship, the state level, the government nominee of the state level scrutiny committee, he was transferred. And that's why the state level committee is yet to take the final decision, Lordship.
Hmm.
That will be taken as soon as the government reconstituted the SLC committee, Lordship.
How many days?
Our direction was to place that before that, and we have placed, a hearing was conducted, Lordship. Now, government nominee, Lordship,
You tell us how
I'm
many
for the-
days you will require to complete the process.
Lordship, I am for the education department, Lordship.
Yes,
And his government nominee is Lordship.
government nominees to be
By
appointed by whom?
That by the Lordship.
Which department? DOP or what?
That exactly that information I don't have, Lordship.
All right, you call the advocate general here then. Call your advocate general. We'll pass over the file.
It will be by the secretary, Lordship. I will get within 2 weeks, Lordship, I will inform Lordship. That
All
will
right.
be
Council, Mr.
SMT, Lordship.
SMT Christie. Just the submits that the meeting of the SLSC was convened, but in the meantime, comma,
And hearing was also,
and hearing was also undertaken, but
Okay.
before decision could be taken, comma, the secretary,
government nominee,
government nominee,
Ananta Kumar Gogoi, ACS.
AK Gogoi, Shri AK Gogoi, joint secretary, has been transferred, and thus, comma, the committee has to be reconstituted. First up, the order under contempt was passed way back on
22/9/2021.
22/9/2021.
Yes.
More than 1 year and 7 months have passed. But till date, the order has not been complied with. It is hereby made clear that in case the compliance report is not placed for the court's perusal on the next date of hearing, comma, the respondent shall remain personally present in court.
Only thing, Lordship, here the government secretary is not a party respondent, only director. Director has done his part, but secretary is not a party respondent in this.
Not a
case.
party.
Yes, Lordship.
Who is the Srimati Suranjana Senapati?
The director of elementary education staff.
She is the director.
Yes, Lordship.
Okay. Then this court shall be compelled to implead the secretary concerned of the government as a party respondent in this contempt petition and to proceed against such officer.
Within 2 weeks,
The
Lordship.
copy of this order shall be communicated to the Chief Secretary, Government of Assam. List on 2nd May. Just convey to your officers the seriousness
Yes.
of the contempt
Yes,
proceedings.
Lordship.
They can't take things for granted.
Yes, Lord.
All right.
Item number 2,
Obliged.
We have already complied that I have already communicated lordship.
Yes, order has been complied.
I have got the order, your lordship.
Give the copy of the order to the
Yes,
council.
Yes, lordship, I have already given.
It's 29th November. What were you waiting for? Why didn't you place this order on record on the last date? This is a communication of 29th November. Why were you waiting so long?
Yes.
Hmm?
Last date is 19th, no?
19 November.
Non-submission of proposal in due time. So you have now to challenge that order.
Yes.
Yes.
Okay, then council, Mr. Chisti has placed on record copy of the communication dated 19th November 2022. Issued pursuant to exercise undertaken as directed by this court in the order dated 10/6/2022. Thus, the said order has been complied with. The contempt proceedings are thus closed. Rule is discharged.
Oblige, your lordship.
Needless to say that the petitioner shall be at liberty to challenge the subsequent communications if so desired.
Matter number 3.
We have already complied, we have given that copy. of-
Same order,
Same order.
communication dated same
Same.
communication.
Matter number 4.
Item number 4, lordships, I have received an information from the lordship, Deputy Secretary lordship, that the government of Director of Elementary Education has already submitted a proposal for commercialization of the service of the petitioner school. And the matter is under process in the department and action will be intimated at the earliest. That is my instruction, lordship.
Then council Mr. Chisti submits that the proposal to
Commercialize the services of the petitioner school
provincialize the services of the petitioner school
has received from the
has already been forwarded to the concerned
secretary
secretary
in the government.
in the state government, and that decision of the state government is awaited on such proposal. Is raised that 6 weeks time
Oblige, your lordship.
may further be allowed to place on record the decision taken pursuant to the by the state government.
Yes.
List after 6 weeks as spread.
Oblige.
All right.
Matter number 5.
Item number 5, lordship, here the secretary has called for an hearing on lordship 11/4, tomorrow, lordship.
Tomorrow.
The hearing will be conducted, lordship. Thereafter, a decision will be taken.
All right.
Informed, lordship.
Hearing
Okay.
of the petitioner in terms of the order dated 3/8/2022 is fixed tomorrow, for tomorrow.
Yes.
The hearing of the appeal in terms of the order dated so and so is scheduled tomorrow, list after 3 weeks.
Oblige, your lordship. Oblige.
The latest factual report will be placed on record by next date.
Yes, your lordship.
Matter number 6.
Yes.
Lordship, here I have received an instruction. Here the dispute is regarding the school allotment of land, lordship. Now
Yes.
that Deputy Director, the Director Elementary Education has written to the lordship, the school, that
Hmm.
particular school, petitioner school, to cooperate with the DEO Tinsukia for tracing out the allotment copy of the land in the name of the school from the office of the Deputy Commissioner.
You place the communication on record.
Yes, lordship.
All right, and
Yes.
Council Mr. Chisti has placed on record copy of the communication dated so and so. Issued from the office of
Director Elementary Education.
Director Elementary Education as per which,
Second last para, lordship.
the process is being undertaken to trace out the copy of the allotment letter whereby, land was allotted to the school in question. How much time is required?
This will take some time because lordship, the corporation of the school also required, lordship.
Okay.
In the district, lordship, that will have to be done.
I direct, instruct my petitioner to cooperate with the.
The
within this
petition- council for the petition shall direct the school authorities to cooperate in the process of identifying the land in question,
Yes, lordship.
land of the
Yes,
school
allotment copy, that.
by providing the relevant documents. The exercise be completed within shall be completed as directed, shall be completed within next 8 weeks, please thereafter.
I have given the copy to him also, Lordship.
All right.
Yes.
Copy of the letter has been provided to the petitioners council. Next.
Matter number 7.
7, Lordship, here, Lordship, we have already
Issued the, pass the speaking order.
Lordship. Here the matter has been referred to the finance department because it is regarding payment of salary, area salary, regular scale of pay to the petitioner, Lordship.
Hmm.
The finance department view is required. Their approval is required. So matter is presently before the on receipt of the view of the finance department, the government department will take up the matter again, Lordship. Final disposal, Lordship. So we're waiting for the views of the finance department. This is the.
This is the third round of litigation. First round rate was decided in 19/7/19. Then again, for non-compliance of that order, further rate was filed. If you are sitting tight,
Until and unless the finance department has to approve, Lordship.
why this required 3 years, Mr. Council? What happened to the order of 19? What you did in the pursuance of the order dated 19/7/19? Read page 11, internal page 3 of the order. The petitioner came earlier,
Yes.
filed similar rate. One order, second order, why does this court is required to pass orders again and again of the same nature in the same litigation?
Lordship, here finance is of the party, Lordship.
Finance is a party.
Yes, Lordship.
Let's issue notice then. Yes.
On the next page, Lordship, so far as this letter is concerned, where it was furnished to the finance department. I think
May I-
what happened there.
May I give the copy?
All right, Mr. Your good name, please? P. Nair. P. Nair appears for the, you can't appear for the department. This is the contender concern, secretary concern
Yes.
for the respond number. To Commissioner Secretary to the Government of Assam Finance Department. He prays for and is granted short opportunity to complete his instructions and ensure compliance of this court's directions. List on 3rd May. Okay. Name of Sri Nayak shall henceforth be reflected in the call list. As already is shown. No need to mention that line. It's already there.
Matter
3rd
number
May.
8.
Item number
Yes.
8, we have compliant, Lordship. Yes.
What do you say, sir?
Yeah, we have rejected his claim because the SLC has, due to
All
non-feasibility
right.
report, Lordship.
Council, Mr. Chisti has placed on court copy of the communication dated 18 February 2023, as per which, the petitioner's case was considered by the SLSC and has not been found acceptable. Thus, the order under contempt dated so-and-so has been complied with. Directions given in the order dated so-and-so have been complied with. The contempt proceedings are closed. Rule is discharged. The petitioner shall be at liberty to challenge the communication referred to Supra by availing the suitable remedy.
Matter
Rule
number 9.
discharge, this will come, Mr. Khan, this will come just after the order is placed on the court. The contempt proceedings are closed. Petitioner shall be at liberty to challenge. Rule discharge will be in the last. Okay. Yes.
Item 9, Lordship, we have already complied with the order. We have already directed the DO Sibsagar to take necessary steps to release the retirement benefit of the under new pension scheme as well as DCSG as per government of Assam. And Lordship, the direction has already given to comply with the order of the honorable court, Lordship. To release the pension under new pension scheme, Lordship.
What do you say?
Lordship, I did not receive these instructions. Just now I have received.
Now you have received it, read it.
Lordship.
There is nothing special about it.
Lordship.
But this is not compliance. Still you are
No, Lordship.
dilly-dallying on only
No,
the DEO Shivsagar is directed to take next steps.
no,
What
Lordship,
steps have been taken thereafter?
Para to make and see already 6,97,640.
All right,
rupees have been
but
received.
still something more she claims.
She has not submitted the Lordship point number 4. The DO Shivsagar submitted the proposal along the revenue record. But the
All
petitioner
right,
did not
she has
file-
not furnished the
file
filled
the
up
field of
forms.
extract from annexure 2 and PAN number.
All right, you,
for
what
which-
you do is you provide a copy of this letter, let him
Yes.
contact the petitioner.
Yes,
The then learned counsel, Mr. Chisti,
Yeah.
has placed on record the communication dated 18th February 23 issued from so and so in perpetuate compliance of the court's order dated so and so. Counsel for the petitioner pays for time to complete his instructions list after 3 weeks.
Matter number 10,
Yes. None present. List of 2 weeks. None present for the petitioner.
matter number 11,
Item number 11, Lordship, we have given the benefit of that, Lordship, all the financial upgradation benefit has been given to the petitioner.
Read, Mr. Counsel, what do you say?
Instruction is necessary.
All right, then government council has placed on record copy of the communication dated so and so, as per which comma. All
The financial upgradation benefit of financial upgradation Lordship that has been given.
accruing benefits of financial upgradation, 3 financial upgradations have been afforded to the petitioner in compliance of this court's order dated so and so. Counsel for the petitioner pays for time to complete his instructions. List on. These are all communications of February.
Yes.
Why
Lordship,
don't you
I
give
think-
a advance copy to the petitioner's counsel?
I think the petition should have got already.
Petitioner must have been conveyed,
Yes,
right?
Lordship.
But you can give a copy to the council, no?
Yes,
So the council can contact and
yes, Lord.
take the instructions. List after 2 weeks. Yes, 12.
matter number 12,
Please, your Lordship.
Yes.
Lordship, the order dated 27/7/2022 has not been submitted. Annexure 1, page number 9, your Lordship.
Mm,
Relevant portion is from page number 11, your Lordship.
mm.
Bottom.
Yes.
Member Ms. Salia Lawrence Training Council appearing on behalf of their respective testament therefore submit that this petition may be disposed of with the direction to the respondent number 3, Director of Indian Education Assam, government body to verify. that-
You have furnished the representation thereafter.
Thereafter, your Lordship, I filed on 4/8/2022. your Lordship.
All right, heard. Issue notice to the respondent number 1. Mr. Chisti appears on our behalf. Copy of the,
Yes.
copy of the contempt petition he provided
Yes, Lord.
to Mr. Chisti forthwith. His name shall henceforth be reflected in the call list. He prays for and is granted 2 weeks' time to complete his instructions and file the compliance report.
matter number 13,
There is only one respondent, then you need not mention respondent number 1. Yes,
The petitioner is filed this petition, yes, the order passed in WPC 8/79/2014.
Mhm. Yes,
The instruction was given to pay a sum of rupees 88,09765.
this is order of 2014. Now you are coming in contempt in the year 2023.
In the meantime, my lord, we are supposed to get the money from the department assured us that they will pay,
Assured us means,
Assured
what is the
petitioner.
limitation for filing a contempt?
Well, thereafter, we, on 1/12/22, my lord,
Hmm,
they have,
okay. All right, all right. Heard, issue notice to the
water source.
respondent. Rule is made returnable in respondent number. Executive engineer. Respondent number 2 to 5.
Yes, ma'am.
steps for service be taken in 7 days. Rule is made returnable in 4 weeks.
Item 14 and 15, my lord.
Yes, 14, 15,
Similar.
similar. All right, same order, correct कर देना इनको. Correct.
Matter number 16.
Okay.
Yes,
May I please, your lordship?
yes.
After filing of the contempt petition, my lord, on the date of listing, lordship, a writ appeal was preferred by the my lord respondent,
Okay,
and in which an interim order was passed.
then
and
you can
fixing-
withdraw this, seeking liberty to file a fresh if so required.
Or my lord, lordship may adjourn it because.
All right, land
writ
council
appeal
for the
is fixed
petition
on tomorrow.
states that a writ appeal has been preferred against the order dated 7/2/2023. An interim order has also been passed. Thus, the instant contempt case is adjourned by 8 weeks awaiting outcome of the writ appeal.
Writ appeal will come on tomorrow, my lord. Fixing. Obliged.
Matter number 17.
May I please, your lord.
Yes.
Lordship, the petitioner is a hospital.
Mhm.
In the writ petition, we have challenged the show cause notice which was issued by the respondent number 2. By the state show cause notice, there was a delay in renewal of the provisional license of the hospital.
Mhm.
So in the show cause notice, there was a specific direction for the closure of OPD, OT and other emergency services in a period of 7 days. So the order of the single judge is at page 13, lordship. The relevant portion,
There are 15.
yes, lordship. Para 14 and 15, 14, lordship. Page number 19. As the disruption of health and services directly affect the public at large, is expected the respondent number 2, Joint Director, Health and Service DFU is in his capacity as convener, district authority shall expeditiously take decision on the representation submitted by the petitioner within a period of 2 weeks. Thereafter, we have submitted the penalty, we have submitted a late fine, and we have also submitted the representation within time period, lordship. And it was duly received on 27/12/2022. Lordship, but till date, nothing.
Third, issue notice to the respondent. Rule is made returnable in 3 weeks. Steps for service be taken in 4 days. Next 3 days.
Much of it.
Matter number 18.
May it please, your lordship?
Yes.
Lordship, I am here on behalf of Mr. HMR Chaudhary, lordship. He, due to some personal difficulty, could not come.
Why contempt petitions are pending for last 4 years? Will to understand?
Brief is not with me, lordship. I am not aware.
You're not aware.
Lord.
Proxy counsel MS so and so appears on behalf of the lead counsel and submits that the matter may be adjourned because arguing counsel is not available today. List after 2 weeks. Yes.
Matter number 19.
Section 19, lordship, we have complied and we have already later on 7 November.
Yes, 7 November letter has been given.
Yes.
I may pay.
An amount of 88,000 has already been sanctioned for payment of area sales to the petitioner law.
Yes. This letter was placed on record on the last date.
Yes.
Yes, what do you say?
My lord, I am appearing on behalf of Bippu Castro. My lord, he is not well today. And to my information, commutation of pension is not received, my lord. Not
Then you have to file an counter or whatever additional affidavit. This order was passed in November, sir.
Yes, look.
We are here in April. If your client is not aggrieved of this letter, then how can we go into the merits now? They said that this amount is due to you. If you want to dispute it, then file a fresh writ petition. How it is a contempt then?
Yes.
we have not received commutation of pension, my lord.
What is the direction? Let us see.
The pension was not a direct part of the direction law. So it was the areas only.
So areas would include everything.
Yes.
Mr. Counsel, areas would include everything.
Yes.
You can't go on a hair splitting exercise. All full area allowances.
Yes.
Page 12, my lord.
Certain amounts toward the competition of.
Full area allowances would include everything.
Yes, Lord.
Commutation of pension There's a specific direction, Mr.
Yes.
All right, keep your secretary present then.
And this 83,000 lordship, I have to,
Is it commutation included commutation in this? Only areas of salary. All right. Council, Mr. So-and-so has placed on record copy of the communication dated 7 November 2022 in purported compliance of the
lordship may.
direction given by this court on so-and-so. A perusal of this order would indicate that the amount towards commutation of pension has not been paid to the petitioner despite a specific direction given on by this single bench by the order dated so-and-so. In this background, the respond number, you want the principal secretary finance to be here?
Lordship, so far as commutation pension is concerned, Lordship, petitioner needs to apply before the authority, Lordship. Only
That is not your case. The court says,
it's computation of pension. Lordship.
yes, as prepared. Already things were prepared, gentlemen.
Lordship, may kindly give me short that let me take a step on whether the
Tomorrow.
88,000 is.
Tomorrow.
includes what, yes.
Simply list on 12th. Yes.
Matter number 20,
Yes.
Yeah, please. Madam, maybe password for a day, madam, or file has been misplaced somewhere.
File has been, record has been misplaced.
Misplaced, madam.
What is your stand, madam?
Lordship, I'm sorry to say, Lordship, due to misunderstanding of this honorable court's order, Lordship, we could not comply to tell you. Partially, we have complied, Lordship. Kindly give us one.
You advise your officer to make a full compliance?
Lordship, yes, I have already advised. He will comply within.
Government Council MS Bora submits that the officer concerned has been advised to ensure full compliance of the directions given by this court by the order dated 3/1/2020, and that she shall be placing on record the compliance report within next 4 weeks. Let's start 4 weeks. Yes.
number 21.
21 lordship, here we have already complied, lordship. We have already given the
Yes.
benefit of regular.
When counsel for the petitioner agrees to the submission of Mr. Chisti that the order under contempt has been complied with. A compliance, the communication dated so-and-so in affirmation of the said fact has been placed on record. In view of the submission noted above, the instant contempt petition is disposed of, rule is discharged.
Highly obliged.
Number 22.
22 is also yours, madam?
22, no.
No.
It's
Okay.
artistic, yes, sir.
RC strike, yes, sorry. Okay. What is the matter, Mr. Chisti?
Lordship, here I have received an instruction from the secretary, Lordship. On examination of the proposal submitted by the secondary education lordship, it was found that there is no clarity against each of the petitioner, as well as under what specific reason each of the petitioner was then not provincialized during the process in the year 2013. The report indicated that there were excess teachers. Subsequently, under what circumstances their specific matters gain eligibility to the set conditions of the Provincialized Act was not specified.
Gentlemen, the direction is
Yes.
that the petitioner shall be provided the benefits of provincialization.
Yes.
So there is no question of your tinkering with that direction by saying that there is no clarity. The specific direction is given.
But they have,
Either you challenge the order,
yes, they have to fulfill some criteria as per the act.
the court doesn't give you that discretion. Lead the order, please.
Lordship, may
Read
kindly
the,
Lordship, may kindly give me some time. Lordship.
read the order first.
Lordship, today I'm extremely sorry, Lordship. I'm handicapped with that particular brief, Lordship. I'm sorry for that.
Why? You're not having the file with you.
That particular file, Lordship, I somehow misplaced, Lordship.
12th. List on 12th.
Sorry, my lord, I am what I want for the petition, lordship.
12th.
Okay.
All right.
Number 23.
23.
23, Lordship, we have already sanctioned an amount of 1,46,892 towards to the petitioner, lordship, for payment of area salary for period of 1/4/16 to 36/2018, lordship.
Provide a copy to the petitioner's counsel.
No, they have not appeared, lordship.
All right, you know the counsel. Don't you know the counsel? RP Hazarika.
RP Hazarika.
All right. Then counsel, Mr. Chisti has placed on record copy of the communication dated so and so, as per which, the a sum of rupees 1,46,892 has been sanctioned to the petitioner towards period of arrear salary within bracket refixation of pay for the period with effect from 1/4/16 to 30th June 2018. As per Mr. Chisti, the said order ensures full compliance of the directions given by this court by order dated so and so. In view of the submissions noted above, which are not disputed because no one is present. On behalf of the petitioner, the instant contempt petition is disposed of. Rule is discharged.
Dispose of, Lord.
Yes. That was the amount. It may be noted that precisely the direction which is given in the order dated so and so is not to effect recovery of this direction to refund or what? Direction which was given by this court by the order dated so and so was to refund this very amount to the petitioner, which was recovered from him in pursuance of an order dated 24/7/2018. As the amount has already been refunded, the order under contempt has been complied with. Hence, the contempt petition is disposed of. Rule is discharged.
Obliged.
Number 24.
Yes.
Madam Lordship.
Sir, Lordship, matter is already complied with your Lordship.
What do you say, sir?
Lordship, the informant documents has not been provided me, Lordship, as on that.
You can provide him the copy of the compliance report or order.
We have also filed an affidavit, your Lordship.
Then what do you say, sir?
Received, Lordship.
Affidavit copy or not received? Give him a copy right now, sir.
Yes, sir.
There is no procedure to provide advance copy. These are RTI matters.
Yes, Lordship. So proceedings, Lordship, the proceedings of the appointment of the principal, Lordship, the principal post, Lordship, record the.
Just read the affidavit, sir.
Oh, yes, sir.
Your Lordship, on 12/3/21, hearing took place, your Lordship, where the appellant was absent, your Lordship.
Right. The appeal has been disposed of in 3 months.
Yes.
That is what the
Within
grievance
this
is.
time frame.
What do you say, sir?
Lordship,
What more?
So the petitioner appeared, Lordship, in the meantime, Lordship. So I don't know what is the effect of this order, Lordship.
The appeal was to be decided. It has been decided. What more is required in contempt proceedings?
In the year of 2019, Lordship, the petitioner filed the application for the record that particular documents, Lordship. So, Lordship.
Thereafter, the information was not provided. You filed an appeal. What is the direction of London single bench? Let us see.
Lordship, relevant param, Lordship.
To consider the appeal.
Yes, your Lordship.
That appeal has been considered and decided. Direction given by London single bench by the order dated so and so. In relation whereto this contempt petition was to consider the appeal of the petitioner filed under section 19 of the RTI Act as per the affidavit filed on behalf of the respondent, the appeal of the petitioner has been decided on by the order dated 12/3/21. Thus, the order under contempt has been complied with in letter and spirit. Hence, the contempt proceedings are closed. Rule is discharged.
Number 25.
Oblige.
Oblige, your
Yes.
lordship.
Make legal losses. So in this case, I would like to file present incumbents number because
All
the
right.
number one is a retired and number two. will have a
Counsel for the
business
petitioner pays for and is granted time to bring on record, complete the incumbents presently holding their respective posts as respondents in this contempt petition. She prays for and is granted 2 weeks time to do the needful.
Highly obliged.
Number 26.
If the order has been complied with.
What do you say, sir?
Lordship, I have to take instruction.
Read the order. If it is very clear that the things have been complied with, then you don't need to bank upon your client.
Yes.
Disbursed.
Yes, yes. Yes, Lord.
Okay.
Yes.
देखिए, then council Mr. So-and-so is placed on record. Copy of the communication dated 7/4/2023 issued by the respondent college as in purported compliance of this court's order dated so-and-so. Order dated 9/4/21. In view of the fact that the amount accruing to the petitioner has been disbursed to her, manifestly the order under contempt has been complied with. Thus, the contempt proceedings are closed. Rule is discharged.
Number 27.
27, I need some accommodation, Lordship. The director with the party series in brief in Lordship. I couldn't get the only a week
And
time.
Ms. Chisti, appearing for the respondent contemptor, prays for and is granted 2 weeks time to complete his instructions
Oblige, Your Lord.
and file compliance report on record.
Yes, oblige, Your Lord. Hello.
Number 28.
List up 2 weeks. Okay. Yes. 28.
Non-compliance of the order dated 16/9/2020 and page 61, my lord.
Page 61.
61 and relevant portion kindly stay, my lord, page 63. Yes, Lordship, second contempt, my lord. Yes, Lordship, here, Lordship, some department has taken up the matter, Lordship, and ultimately found that the petitioner Rabindranath Ghosh falls under the category of illegal and irregular incumbents of Dhamadi district. So now for further compliance with the order, the matter was placed before the expert committee, Lordships, and its outcome and decision is, Lordship, we are waiting within the 7 days, Lordship, will inform this court, Lordship. The outcome of the expert committee, Lordship.
How much time do you
7
need?
days, Lordship.
7 days.
Yes, this is the instruction.
All right. And counsel, Mr. Chisti submits that accommodation of 7 days may be granted to the officers concerned to ensure full compliance of the directions given by this court. He has placed on record a copy of the letter dated 8th April 2023, as per which, the expert committee is already considering the matter and the decision will be intimated in next 7 days. List after 2 weeks. So as to enable Ms. Chisti to place on record the steps taken in compliance of the order.
Number 29.
Yes.
May I please, your Lord. Lordship, here would a service was completed or not, like, because B. Colin Sudi is no more an principal secretary. He was a principal secretary long back, Lordship.
You substitute.
Will substitute.
And then counsel for the petitioner pays for and is granted 2 weeks time to substitute the incumbent presently holding the post of principal secretary secondary.
Now only secretary school education. That post is no longer.
Okay. Office to substitute the respondent by the appropriate officer.
Yes. Oblige.
Done. One more.
Item number 30.
Okay.
Lordship, here also I need some 2 weeks time, Lordship, to get the full instruction.
My lord,
We are considering
communication made by the director, my lord.
We have already received the proposal from the district, Lordship.
All right.
So 2 weeks more time.
Chisti prays for and appears for the respondent condemner. He
Yes,
prays for and is granted 2 weeks time to complete his instructions, file compliance report on record.
Obliged. It is marked.